Today, 16 states have sued the U.S. government through its agency, the DHS, over the new U.S. immigration reform program that will give legal status to more than 500,000 undocumented immigrants in the United States who came into the U.S. or who entered the United States unlawfully. The program is known as the Parole in Place program or the Keeping Families Together program. So the program started on Monday, August 19th. USCIS started accepting applications, and thousands of people have already submitted their applications, and we are already seeing cases getting approved within 2 days of submitting cases. Bear in mind that this new Parole in Place program allows undocumented immigrants who have been in the U.S., who entered illegally, to get approved. They get legal status, and then they can apply for work authorization or work permits or employment authorization documents, and then they can also apply for green cards without leaving the United States. Now, these 16 states have challenged the new Parole in Place law, stating that the Department of Homeland Security, DHS, has undertaken an unlawful action by creating a program that will grant hundreds of thousands of undocumented immigrants a parole in place. Long-standing federal law in the U.S. does not allow immigrants who entered into the U.S. unlawfully to get most immigration benefits. So, for example, if you enter the U.S. illegally, you cannot generally get a green card or lawful permanent resident status without first leaving the United States and waiting outside the United States for some time. According to the lawsuit, these provisions of law that have been established by Congress, they act as a powerful disincentive for people, or it discourages individuals or immigrants from crossing the border to unlawfully enter the United States. The 16 states say that the action of DHS incentivizes illegal immigration and it will irreparably harm them. Additionally, they're stating that the U.S. government or the DHS is not utilizing its parole power properly. Okay, the immigration laws, so that's the INA, details the specific instances when the U.S. government may use its authority to parole individuals into the United States. These are individuals who would otherwise not be lawfully permitted or allowed to enter the U.S. Specifically, Congress has directed that parole may only be granted on a case-by-case basis, and even then it's for urgent humanitarian reasons or significant public benefit. Now, let's look at the states that have sued the U.S. government. These states tell us the number of undocumented immigrants married to U.S. citizens. The first state listed as plaintiffs in the suit is the state of Texas. Texas says it has 204,000 undocumented immigrants that live in the state of Texas who are married to U.S. citizens. Number 2 is Idaho, has 4,000. Alabama has 7,000. Arkansas has 6,000. Florida has 93,000 undocumented immigrants married to U.S. citizens. The state of Georgia has 34,000. State of Iowa, number 7, has 6,000. Kansas, number 8, has 9,000. Louisiana has 7,000. Missouri has 9,000. North Dakota, number 11, has 5,000. Ohio has 14,000, number 12, and 13, South Carolina has 9,000. Number 14, South Dakota has 7,000. Number 15, Tennessee has 12,000. And number 16, the state of Wyoming is saying it has 7,000. Undocumented immigrants who are married to U.S. citizens who live in the state. And that's how come they're saying they will be caused irreparable harm if this law is not struck out. Okay, so what are they asking for? They are asking, these plaintiffs that I've listed, they are asking for a temporary restraining order or an order to stay the defendants, which is the U.S. government's implementation of the PIP, Parole in Place program, and to stay the approval of the form I-131F, which is the form that is being used for the application of this legal status. They're also saying that they want the court to decree that the PIP program, as well as the Federal Register Notice, the filing guide, the form I-131F, they were all issued in violation of the Administrative and Protective Act, and then to vacate them, set them aside, and to permanently enjoin the defendants from implementing it. And then the third thing they're asking for is they want a declaration that the PIP program, including all the notice filing guides, those exceed the defendant's statutory authority and the regulations, meaning the US government has likely acted ultra vires. Okay, then fourthly, the plaintiffs are stating that they want attorney's fees and costs of court. So they want to be refunded or reimbursed, or they want to be paid the attorney fees and costs of the lawsuit. And then the fifth thing they're asking for is that the court should award the plaintiff states all other reliefs to which they may be entitled. So if you have not yet filed your parole in place, or you don't even know what's going on, you don't know whether you're eligible, please give us a call. We'll be happy to help you. 802-780-0564. I hope this information helps. Don't forget to like, share, comment, and follow us for more. I'll see you in the next video. Bye.